Legal showdown between the Information Regulator and the Basic Education Department adjourning for a while at the High Court in Pretoria. The regulator, of course, has filed an urgent application to stop the publishing of matric results in newspapers. In fact, the Information Regulator's chair, that's Bansitla Kula, says the department's intention to release these results in the newspapers actually doesn't comply with the Protection of Personal Information Act. Watching developments for us is Patricia Vasaki, who joins us now live from just outside court. Patricia, I understand it's a short adjournment. Tell us why we had to take this break.
Well, of course, you'd understand that the matter is in the Palace of Justice. It is before Judge Ronel Tolme. And one of the biggest challenges here that's obviously at the center of this court case is whether it is an urgent matter and what exactly are the bases to motivate or substantiate for that urgency. So there has been that discussion between the judge and the legal team. So, of course, just a short break just to go and verify certain information. But just to take you back, this is a battle that is not new. It actually started in 2021, 2022. Afriforum at the time leading the battle. They won the battle, and they are back here. And it's the same battle that they're waging. I'm now joined by Ilana Bailey from Afriforum, just to ensure the importance of making sure that the matric results are published the traditional way, which is in the papers and so forth.
It is very important for a lot of matriculants to receive the information about their results in that manner, and a lot of our members approached us and asked us to defend that right in 2021. So we feel confident that because the judge ruled in our favour in 2022, there is adequate protection of the privacy of learners, while at the same time the public interest is addressed.
And talking about that privacy, previously it was moved to a point where the full identities of the learners was not, published, and just their examination number, that was part of the protection.
That's correct, yes. In 2014, the department started publishing only the examination numbers. So that already makes it very difficult for an outside person to know whose results they are viewing. But at the same time, the matriculant can easily access his or her information.
We understand that Afriforum also feels that the judgment that was passed in 2022 still stands.
Yes, definitely. At that stage, it was said that there is adequate protection for learners if the examination number is used, and the judge issued an order, and I think as the Department of Basic Education also states at this stage, they are still bound by that order.
The other challenges that have compelled Afriforum to act on behalf of your members and, of course, the matriculants at large. At the time, I remember one of the arguments was that not all the learners in particular far-flung areas where there are network challenges and so forth would have the privilege to access that information should it be released online, for instance.
Yes, that's definitely an issue, and also for people who are on leave and who go to very far-flung areas, it's important to have a different way of accessing the information. And then also in publications, there's an opportunity for specific notices, advertisements and other forms of information to be published together with the results where the matriculants can easily access it. So I think the printed media still has a huge role to play in this regard, provided that they are still allowed to publish the results.
All right, thank you so much. Of course, you would hear that there are perhaps tangible reasons why organizations such as Afriforum and the Department of Education, Basic Education itself finds grounds to have the matric results published the traditional way, that being in the newspapers. There are a lot of factors that they are arguing, and Afriforum being confident that perhaps the order, the verdict that was issued in 2022, that still stands and it can be upheld. But the biggest argument here is the matter of urgency, and that is basically what is now being discussed. Is this an urgent matter? Should the arguments be heard on an urgent basis? And what are the legal components that makes it compelling for it to pass as an urgent application that should be heard? The judge even making it very clear that some of the elements within this case are so complex that they actually can be ventilated at a later stage, and you can have a full court case that is not rushed, that can actually look at the various aspects of the act that the Information Regulator is using to obviously try and block the matric results from being published the traditional way. So we'll have to hear when she comes back exactly, what are the discussions that took place behind the scenes and how exactly will this matter proceed for the rest of the day.